Hail to legal warriors, this is a cautionary tale. It is more than just talk. You have to know these things to not accidentally get caught violating a no contact order or protection order. If you're interested in this area of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 20 years, and I'm putting out these videos to help educate the public. I hope you find this useful, so I'm just going to jump right into it. It is more than just talk. So many people nowadays end up having a protection order against them or a no contact order against them, and they don't really read it that close, and mainly they don't think about what are the ways that they could violate this order from the court that may end them up in jail, or even worse, with dozens of new charges. And now I'll take a step back real quick. What do I mean by a no contact order or a protection order? Well, a no contact order usually comes from a criminal case. Someone's been arrested, typically for a domestic violence crime, something like that. And once they get released, they say, hey, while the case is going on, the court says you can't have any contact with whoever the alleged victim is. And there's going to be a piece of paper that says what the no contact terms are. For a protection order, which some people would call a restraining order, that's a civil order where there's a petitioner, just some human, not the government, who asks for restraint provisions against the respondent. Could be a neighbor saying, I'm being harassed, that the respondent neighbor is harassing the other neighbor. It could be also a domestic violence situation, boyfriend versus girlfriend, girlfriend versus boyfriend, girlfriend versus girlfriend, whoever. And it could also be situations about SA. It could also be vulnerable adult. Lots of different ways you can have an order. And what most people can make a mistake in is they understand that no contact means, hey, I can't call the person or I can't talk to the person, but they don't think about all the other ways we could have contact with somebody that is through means besides direct communication. So what's the first thing that comes to mind? The first and most important thing, and what my staff was just yelling to me about, was social media. We have seen this really big influx of cases here where the other side of the police, they happen to allege contact when the restrained person, the defendant or the respondent, is simply looking at the social media of another person. And there's all different types of social media out there right now. There's Instagram, there's X, there's Facebook, Snapchat, and they all sort of have their own different ways that somebody can tell if you've looked at their social media or not. And we've actually seen cases where the protected party has called the police simply because they could see that the restrained person is looking at their story somewhere. And how would that possibly be a violation? Well, usually these no contact orders have a restraint that says you can't monitor someone, that you can't stalk someone, that you can't cyber harass, stuff like that, but it's very broad. You can't keep someone under surveillance is usually what the order says. And then under surveillance, what does that mean? Right? What does that mean? And all it takes is one government official, one police officer, or one overzealous prosecutor who doesn't happen to like the defendant for some reason to go, hey, you can't watch their social media. That's surveillance. You're causing them abuse by watching their social media. And now you get a police report and you might even get arrested. What's another example of a social media problem? Well, this one's a little more clear. What if you like someone's post? Right? What if you tag someone in a post that you're restrained from communicating with? Is that communication? Is that contact? Well, I don't think you should take the chance, because if the government claims it's contact, if that police officer, if that overzealous prosecutor says it's contact, next thing you know, you're in jail, you're getting arrested just because you were clicking around on the computer. Now, let's face it. We all want to be curious about what's going on. We want to know what other people are saying about us, especially if they're accusing us of something. But it's really not safe for us to be monitoring other people's social media in any way. So what are my big tips when it comes to social media? Just block the other person, right? Just block the person that has the order against you. Make sure you don't tag them in anything. If you're really curious about it, you might have a friend who can look at it and communicate to you what's there, and that's probably not going to get back anywhere. But what you don't want to do is you don't want to give somebody the opportunity to claim that you're monitoring them or to claim that you're communicating with them because you happen to like some type of post. So social media, that's a big no-no where we can get arrested accidentally by not doing something on purpose. What's the second thing we need to worry about besides the social media? Remember, it's more than just words. In this case, it's more than just talking. Being in the same area as someone else and not leaving if they end up in the same place is another problem. Usually protection orders have a distance restriction. We have to stay a certain distance away from someone's residence or their workplace or usually their person. And what can happen, I've seen this happen, especially, I don't know why it's on the east side, I see it on east side cases. There's a lot of social places, a lot of people go to bars, and the restrained person's at a bar, they're over at Joey's or somewhere like that, and they're having a drink, they've been there for 2 hours, and here comes in the protected party. And that restrained person says, hey, I don't need to leave, I was there first. That protected party sees the restrained person, they call the police. The police don't care who was there first. The requirement on the restrained person is to leave if they are in the same place as the protected party. Now, it's different, not if you're at your house. You don't have to leave your own home if you don't live with the person, right? But you do have to do unreasonable things if you're the one restrained. I've seen it happen at kids' soccer matches, right? You got two parents, and one parent's watching the soccer match. They're restrained from the other parent. The protected parent shows up. The other person's got to leave now. Even if the protected party is using that as a weapon, we still have to obey the order so we don't get arrested. That's a big one we have to watch out for. Number 3, the third way we can get in trouble without having that direct communication is third-party communication. I've seen this happen also in the last 12 months. It doesn't happen a lot because we warn the people that we talk to, but sometimes people call us on the phone with the situation. You can't have somebody pass a message on to the protected party. In other words, hey, tell Bill that I need my computer and I'm going to send someone to come pick it up. Well, if that person communicates that message directly to Bill and Bill's protected from you, the one saying it, that's third-party communication. A more safe way to do it is you have your friend say something like, hey, can I come get the computer? Without passing any message on at all. And that's a way we can avoid, unintentional third-party communication. The fourth problem I see is people not being careful with their emails. Sometimes we end up with some type of, relationship aftermath that we have to unwind. It might be apartments, whether or not we have an apartment that we need to split up now. Sometimes we have the same type of workplace and we're on an email chain. We have to be careful if there's any chance that the person that's protected happens to be on some type of email communication chain. When you reply, you cannot reply to all. I've seen that happen in 2 different cases in my career where someone replies all in a situation. There might be 100 people on there and that are all getting CC'd. And that reply all ends up sending the message to the protected party. And that's a communication, even if you didn't intend it. If you send it and it gets to them, that can easily be said to be a communication that violates a no contact or protection order, and that's something that we just can't have happen. So what's the summary of this? If you happen to be restrained by an order, remember, it is not fair. Do not operate on a what's fair basis. Operate on a what's safe basis, because we cannot leave our freedom up to the interpretation of law enforcement who is naturally against us because we are restrained. And so the big gotchas are that social media, which I started with, the Snapchat nightmare, the Instagram nightmare, the Facebook Meta nightmare. It all happens in real life. So please be careful. Remember, if they're in the same place as you, you need to leave. If a third party is going to communicate with them, you got to be careful they don't say the wrong things. And finally, email communication doesn't happen as often, but when it does, it's really hard to get out of that problem. So if you found this useful, please like and please subscribe. More people get to see it, more people get the help they need. And more importantly, if you have a criminal matter in Washington State, feel free to reach out to my firm. If we get on board, we'll listen to what happened, we'll identify a way forward. We will be there for you. Thank you.